What a time to be alive. Folks, the constitutional cavalry has finally arrived, and they are not just riding to the rescue. They are laying siege to the bureaucratic citadels of gun control. We are witnessing an unprecedented and historically significant convergence, a Supreme Court ruling that obliterated the tyrannical may-issue permit regimes, coupled with the Department of Justice, yes, the federal government itself, wielding that constitutional mandate to file the first affirmative lawsuit in support of gun owners. They are specifically targeting the egregious rights-infringing delays imposed by agencies like the Los Angeles County Sheriff's Department. This is not a drill. This is the definitive end of the era where politicians in blue states believed they could veto your fundamental, God-given right to self-defense. The permit wall is crumbling, and the political and legal aftershocks are setting freedom across America. For decades, the anti-freedom lobby operated under the delusional assumption that the Second Amendment was merely a suggestion, protected only if you could convince a local bureaucrat that you were sufficiently special to merit a concealed carry permit. They called this the may-issue regime, a discretionary power that stripped constitutional rights from over 70 million Americans. Well, the joke is definitively over, because the Supreme Court dropped the hammer with Breuan. The 2022 decision didn't just strike down New York's arbitrary proper cause requirement, it imposed a scorched-earth legal standard, the text, history, and tradition test. This means that if a modern gun regulation, like the subjective whim of a county sheriff, wasn't consistent with historical traditions of firearm regulation around the time of the nation's founding, it is automatically presumed to be an infringement. This monumental shift instantly put the licensing laws of states like California, New Jersey, and DTCC in fatal jeopardy, forcing them to transition from discretionary may-issue to mandatory shall-issue permitting systems. The message is crystal clear: the right to bear arms extends beyond the home, and Justice Kavanaugh himself clarified that the ruling targeted only the discretionary licensing regimes. When the plain text of the Second Amendment covers the regulated conduct, it is presumptively protected. This seismic legal shift has prompted gun rights advocates to launch a deluge of legal challenges, proving that the era of state officials having broad authority to deny permits for arbitrary reasons is officially over. The foundation of the entire permit bureaucracy, the concept of having to beg for permission, is now constitutionally unsound, leading us directly into the current legal war zone in California. I had to check the calendar, because for years, the Department of Justice seemed more interested in hunting down pistol braces than constitutional infringements. Yet, here they are, riding in like the cavalry, filing the first affirmative lawsuit in support of gun owners in the nation's history on September 30, 2025. The target, the very heart of anti-gun absurdity, the Los Angeles County Sheriff's Department, LASD, and Sheriff Robert Luna. This isn't just bureaucratic paperwork. This is the federal government weaponizing the Breuan ruling to protect your rights. The DOJ's Civil Rights Division initiated its investigation on March 27, 2025, specifically because of numerous complaints of unreasonable delays in processing concealed carry weapons (CCW) permits. Attorney General Pamela Bondi did not mince words, stating emphatically that the Second Amendment is not a second-class right. She warned that Los Angeles County may not like that right, but the Constitution does not allow them to infringe upon it. The lawsuit, filed in the U.S. District Court for the Central District of California, alleges a pattern and practice by the LASD of infringing the Second Amendment rights of law-abiding citizens. This aggressive action is a direct result of the Trump administration's Second Amendment Enforcement Task Force, which is prioritizing gun owners' rights. It is truly a remarkable sight to see the federal government suing a local jurisdiction for intentionally obstructing constitutional freedom. This lawsuit demands a permanent injunction to force the Sheriff's Department to issue CCW licenses in a timely fashion under the law. If you ever needed proof that the system in places like Los Angeles is designed for intentional deprivation rather than objective evaluation, look no further than the numbers cited in the DOJ complaint. After analyzing data spanning over 8,000 CCW permit applications, the Justice Department discovered that the LASD had revealed only 2 approvals. 2 out of 8,000 applications. They found 2 people worthy of exercising a constitutional right. That's not a background check. That's a constitutional denial lottery. The delays detailed by the DOJ reveal the LASD's criminal negligence. The department was reportedly setting up interviews for license approval as far out as 2 years after receiving the completed applications. State law requires an initial determination within 90 days, yet applicants were waiting an average of 281 days, more than 9 months. Just for the processing to begin, acting Usali Zes, Attorney Bill Asili slammed this bureaucratic stalling, noting that citizens living in high-crime areas cannot afford to wait to protect themselves with firearms while Los Angeles County dithers. The lawsuit correctly frames these statistics as representing thousands of law-abiding citizens who were stripped of their constitutional right to self-defense outside their homes. Furthermore, the DOJ established a dedicated mailbox for citizens nationwide who haven't received a decision within 4 months, proving the federal government is serious about tracking and fighting these delays. When caught violating the Constitution, what does a sprawling blue state bureaucracy do? They blame the paper and complain about their staff shortages. The Los Angeles County Sheriff's Department, through spokesperson Nicole Nishida, quickly disputed the DOJ's figures. They claimed that their CCW unit had been issuing permits at a significantly increased rate and has approved more than 5,000 permits since the start of 2025, including 2,722 new applications. Sheriff Robert Luna, according to the department, inherited a dysfunctional system and has since reduced a backlog that once stood at roughly 10,000 applications down to about 3,200. The department attempted to excuse the damning data cited by the DOJ by claiming the information was requested during the early stages of a transition from an outdated Sirois manual paper system to a new online platform implemented in May 2023. They also threw in the classic political excuse, a significant staffing crisis in the unit that approves applications. However, constitutional rights cannot be outsourced or delayed due to staffing shortages. The LASD stopped enforcing the arbitrary proper cause requirement following the Supreme Court's 2022 Breuan decision. The fact that these backlogs persisted demonstrates that the bureaucratic resistance to the Second Amendment continued despite the legal mandate. The DOJ's demand for a permanent injunction shows they are not buying the excuses about outdated systems or staff complaints. They are demanding immediate constitutional compliance. For the anti-gun lobby, permits were always the golden goose, a mechanism not just for control, but for revenue and suppression of gun ownership. Now that the system is collapsing, we are seeing exactly what happens when those chains are removed: the loosening of concealed carry weapon CCW laws. Specifically, the adoption of the shall-issue model, which removes discretionary power from local officials, has led to a major increase in legal firearm purchases. This isn't speculation. The fact CCW shall-issue adoption increases online handgun purchases by 21% and handgun background checks by 35% compared to more restrictive laws. This surge is overwhelmingly driven by repeat gun buyers, suggesting that existing CDC law-abiding gun owners were previously restricted from carrying. More importantly for the debate over high-crime areas, the increase in handguns induced by the shall-issue shift is substantially greater in high-crime and urban areas. The evidence proves that the may-issue discretionary permit system was the specific barrier that prevented the people who often need self-defense the most, those in dangerous urban areas, from legally exercising their rights. The firearms purchased are typically new handguns with calibers suitable for concealed carrying. In contrast, the subsequent shift to CCW permitless carry constitutional carry, which eliminates the permit entirely, has no statistically significant effect on new gun purchases, confirming that the initial removal of bureaucratic discretion was the critical constitutional catalyst. While the courts are busy dismantling state tyranny, the legislative branch, under the staunchly pro-gun Trump administration, is moving in for the kill. They are using this momentum not just to fix the damage, but to lock in freedom nationwide. The administration is focused on regulatory rollback and the aggressive expansion of firearms access. A centerpiece of this strategy is the Constitutional Concealed Carry Reciprocity Act H.R. 38, introduced in the House in January 2025. This bill, which the House ordered to be reported on March 25, 2025, aims to treat a concealed carry permit like a driver's license. It would create a federal statutory framework requiring that if you are eligible to carry in one state, that right must be recognized in all other states that allow concealed carry. The bill explicitly preempts most state and local laws related to concealed carry. Gun rights groups are rightly celebrating. noting that 29 states have already adopted constitutional carry. The American Firearms Association points out that these changes have occurred all while gun control strongholds like D.C., Chicago, and California have descended into violence and deadly chaos. President Trump has promised to sign reciprocity into law, calling it a common-sense solution to ensure the right to self-defense doesn't stop at a state line. This legislative effort, combined with the administrative push to eliminate Biden-era rules on ghost guns and background checks, signals a full-scale assault on every gun restriction enacted by the political left. The immediate response of the anti-gun left after Breuan was to invent new gun-free zones. They called them sensitive places, to render the right to carry virtually meaningless. They tried to classify everything from Times Square to public parks as constitutionally off-limits. But the judiciary is seeing right through their transparent workarounds in a massive victory. A Texas federal judge, citing the Breuan history test, ruled that the U.S. government cannot constitutionally ban guns in post offices or on postal property. Judge Reed O'Connor found that the prohibition on firearms on postal property didn't appear until nearly 200 years after the founding in 1972. He flatly rejected the government's argument that post offices are sensitive places, akin to courthouses or legislative assemblies. As Firearm Policy Coalition President Brandon Combs noted, governments cannot invent new so-called gun-free zones wherever they please. Meanwhile, New York's attempt to cling to subjective control by requiring good moral character to obtain a license and banning carry in a massive list of sensitive locations is facing relentless legal fire. Though the Supreme Court declined to immediately hear the challenge to the good moral character rule in April 2025, the second use substitutes. Circuit Court of Appeals was already forced to block the state's ban on concealed carry in certain privately owned retail establishments, such as supermarkets and restaurants. The gun rights challengers correctly observed that New York's expansive list of sensitive places covers virtually the entire landmass of New York, making carrying a weapon so risky that even the hyper-law-abiding licensee would not dare. This proves their intent is not safety, but total nullification of the Second Amendment right to carry. If you want to see pure legal panic resulting from the Second Amendment being properly enforced, look no further than Florida. In September 2025, a state appeals court struck down Florida's decades-old ban on openly carrying firearms because no historical tradition supports Florida's open carry ban. Attorney General James Uthmeier immediately declared it the law of the state, advising law enforcement not to arrest law-abiding citizens carrying visible firearms. However, this victory immediately exposed the absurdity of existing gun control laws, creating what one Democratic state representative aptly called a hot mess. The confusion stems from the law establishing prohibited places like jails and police stations. That law primarily stated that a concealed weapons license doesn't authorize carrying into sensitive areas, but with open carry now a constitutional right. Gun rights proponents argued that the prohibited places don't technically apply in many locations. The biggest loophole involves long guns, rifles, and shotguns. The state law prohibits carrying handguns into sensitive places. But David Marcy, general counsel of the Florida Police Chiefs Association, noted a gap: the law does not expressly prohibit the open carrying of long guns in prohibited places, following the appeals court ruling. Polk County Sheriff Grady Judd noted the ruling makes the rest of the law a little wonky, advising citizens to be very, very careful. This entire situation perfectly illustrates how rapidly arbitrary regulations crumble when confronted with the actual historical standard required by the Supreme Court. The DOJ's lawsuit against LA County is just one part of a comprehensive, ideological project by the Trump administration to align the entire federal regulatory system with an absolutist view of the Second Amendment. This is total war on gun control, led by Attorney General Pam Bondi and the Second Amendment Enforcement Task Force. The administration's strategy includes strategically abandoning the defense of certain federal gun laws in court. The DOJ has dropped appeals on major rulings that struck down possession bans for certain nonviolent felons and the federal ban on licensed dealers selling handguns to 18 to 20-year-olds. Furthermore, the DOJ is aggressively intervening in state cases, filing amicus briefs that challenge far-reaching locational restrictions in Hawaii and California, and state assault weapon bans and large-capacity magazine bans. The DOJ argues that these state restrictions violate the Breuan Directive, stating they are motivated by anti-gun animus and effectively nullify the general right to publicly carry arms. They are pushing a general law theory of the Second Amendment, which seeks to distill broad historical principles to invalidate modern restrictive laws. The administration views gun violence through a strict law and order lens, not a public health issue, doubling down on deregulation and prioritizing armed enforcement. This clear, aggressive political and legal stance signals that every remaining piece of restrictive legislation must now fight for its life under the rigorous constitutional standard. The landscape of gun rights in America has fundamentally and irreversibly shifted. The combination of the Supreme Court eliminating discretionary may-issue permits, the Trump administration's unprecedented use of the DOJ to sue anti-gun states like California for constitutional infringement, and the resulting regulatory chaos in places like Florida marks the end of the era of government permission slips for self-defense. The data proves that removing these arbitrary barriers motivates citizens in high-crime areas to arm themselves legally. The political and judicial momentum is clear. The Second Amendment is no longer a second-class right, and its protections are being restored nationwide. The fight is moving fast. If you believe that your constitutional rights should not be delayed or denied by bureaucratic sabotage, hit the like button and subscribe now. Drop a comment below. What will the gun grabbers try to ban next? Now that permits are DOA, stay smart, stay informed, stay free.